All right, quick check. When was the last time you updated any beneficiary? 5 years ago? 10? Today, we're talking about estate planning. To overview this, the 3 steps that actually finish an estate plan when a revocable living trust is a game changer, when it's actually overkill. 2, tax wins that a lot of people miss. I've witnessed many times. And the easiest way to get everything done, whether you're doing it yourself or you hire somebody for help, stick with me for the next 10, 12 minutes and you'll know exactly what you need to do to make sure that your family's taken care of if something happens to you. Let's start with the finish line, the 3-step framework to actually get this done. I've seen so many people do 1 of the 3. Some people do 2 of the 3. Halfway, very few people that I've ever met with have covered everything as fully as is actually necessary. So 1, put what you would want to have happen if you were to pass away or be incapacitated in your own words on paper. It doesn't have to be in legalese. It takes 80 pages to say anything in legalese. Just put it in your own words. If you have young kids, who would be their guardian? What would you want to have happen to your money? Are there any restrictions? Who's making decisions for you? Just however dumb it sounds in your own words, just say it that way. And then draft the documents. We'll talk about what documents you actually need. Power of attorney, maybe a trust, depends on your situation. But the idea here is that 1, if you can say it in your own words, some type of professional, some type of guided software will be able to put it into legalese. And then 3, this is the big one. So many people miss this. Align your assets with the documents that you just created. I'm not sure if I've ever met someone, when I've reviewed their estate plan, that they had all of their assets aligned with the documents that they created. And the problem is, it's wasted energy. If you create this great revocable living trust, but you don't put your house in it or whatever the thing is, if you don't update beneficiaries, then it was a waste of time. Not fully, but largely. You still end up having to go to probate and have all these fees and delays and all that stuff. And so those are the 3 steps. Number 1, put it in your own words, however dumb it sounds. Number 2, draft the actual estate documents. And then 3rd, this is the big one, you have to update assets, update beneficiaries, update titling, ownership of things to coordinate with the documents that you created. If you don't do all 3 of those, it's not going to be right. And it's largely a waste of time. It doesn't take that much time, and it really doesn't take as much money as most people think. Core documents, I have a cheat sheet guide here at the bottom. It's on the link to walk you through these. So pause, download it if you want to. There's essentially 5 documents, 5 different things that need to be covered. Will, a lot of times in our American lingo, we say we need to get our wills done. And really that's just 1. The most important thing that it does is names guardians if you have minor children, but it's the basic marching orders. It's actually a pretty simple document. Next, durable power of attorney. Think financial power of attorney. That allows someone to act on your behalf if you're incapacitated but still alive. Healthcare directives and HIPAA release. That gives your medical wishes, you get put on life support or not, and gives someone medical access, just like the financial access on the financial power of attorney. A beneficiary update, so making sure that your bank accounts have transfer on death instructions, that your IRA or your 401k has the right beneficiary on there. I've seen people have a lot of ex-spouses as beneficiaries. And the thing about beneficiary designations, it doesn't matter what you put in your documents, they supersede a will or a trust. And you want to make sure that those are accurate and updated. And then the last, a trust, most commonly a revocable living trust. Think of that as a bucket that everything flows into, and then it has certain rules that filter everything out, how you would want them to be distributed. Almost everyone, I think it's fair to say, not everyone, you can't have blanket statements, but almost everyone would benefit from a will, power of attorney, medical directives, and cleaning up your beneficiary designations. Some people don't have beneficiary designations on everything. Some of them are outdated. But almost everybody needs those documents. The trust, there's a bit of a split here where some people need it, some people don't. The most common 2, I would say, first, if you have minor children, and blend it into number 2, if your net worth's over, say, $1 million-ish, something like that. When you say net worth, it's not just your assets, it's your assets plus life insurance death benefit, because when you pass away, that cash gets dumped into your estate and that counts. So you got $500,000 house, $500,000 401k, and $1 million life insurance policy. At death, that's a $2 million estate. So just keep that in mind. But the idea here is if you have minor children, this happens all the time. It's really unfortunate, in my opinion, how the laws work, but it's what it is. Say, picture a 5-year-old kid, both parents pass away. They had a $2 million estate. At age 18, at age of majority, most states that's age 18, that $2 million gets funneled to them with no restrictions at all. They haven't even finished high school yet. And they now have $2 million completely unrestricted. And that often causes more problems than no money, and sometimes does. And so a trust allows you to set rules for minor children of some level of restrictions in how they get money. I think pays for healthcare, education, maintenance, support, and then you get it all at age 30 or something like that, 25. You can do whatever you want. You can say they have to spin around in a circle 3 times before they get the money out. You can literally make up any rules you want, maybe income matching. There's a lot you can do there. But the idea is that at age 18, if you have a decent sized estate, most children aren't ready to manage large amounts of money. The net worth thing, even if you don't have children, probate fees start to sting a lot. 3 to 7% is what I've seen of fees for attorneys, court costs. $1 million, that turns into a hefty sum of money. And if you have a trust, then you can avoid probate fully. If you have property in multiple states, around where I live, that's relatively common. You can have multiple probates, so the cost doubles. Even if you have a lower net worth, it can make sense. If you want privacy, if you have a blended family, you don't want everybody knowing your business. If you have a trust, not everyone has to know. If it goes through probate and you don't have a trust, then everybody can know. And then if you have a kid with special needs, that's a great reason to have a trust. A lot of tax reasons, a lot of government benefit reasons, a special needs trusts help a lot. Any of those situations probably make sense to have a trust. Sounds to a lot of people, if you're first generation successful, so a trust fund, that sounds like somebody that's really wealthy, and that isn't necessarily the case. Any of those reasons are great reasons to have a revocable living trust. Another thing is that if they're set up correctly, a trust can, if your kids inherit money, say you're older, you don't have minor kids, but say you're 65 and your kids are 35, I don't know, and you pass away and money goes into the trust, it can be protected in the event of divorce or lawsuit. There are ways to shield those assets because they don't automatically send them out to the kids. They're held in trust. The kid would have the option to take money out if they want to, but they don't have to. And that while they're in there can be on some level protected, which is pretty nice. Probate, that's basically the court, if you think of it that way. If you pass away and you don't have a trust, everything that doesn't have a beneficiary designation, think your house, think bank account, you didn't have a transfer on death designation, your personal assets, that goes through probate, and it can take a long time. Usually it's months, 6 months, something like that. It depends on how busy the court is, essentially. But the costs are pretty hefty when you have a large net worth. If you have $100,000 net worth, not as much, but if you have a decent net worth, then those costs can be dramatic. And ultimately, a judge decides, not you, what happens to your money. And I love the story, if you're convicted of like murder or something like that, statistically higher likelihood of a life sentence if the judge hears your case after lunch on a Friday than any other time in the week. What that means is judges are humans too, and it depends on the mood and how much detail they have. And most people don't want a judge deciding what happens to their stuff. Most of the time they get it right, but it takes a while, it's expensive, and sometimes they don't get it right, and you can take care of that if you get your estate planning done correctly. A couple bonus tax wins, I guess you could say, 2 rules or strategies to keep in mind. One is step up in basis. When you own an asset in America and you sell that asset for a gain, whether it's anything it is, then you owe capital gains tax. If you say you had a rental property, you bought it for $100,000, now it's worth $500,000, and you sold it, you would owe $500,000. You would realize $400,000, of capital gain, and you would owe tax on that. If you pass that to a beneficiary, though, they get a step up in basis. So it's as if they purchased the property from a tax perspective the date that you passed away. And a lot of well-meaning people transfer assets to their kids while they're still alive, and they miss out on that tax benefit. And then 2, Roth conversions. If you think classic millionaire next door, worked at a factory, funded their 401k all their life, it's all tax-deferred money. When you pass away, the kids have to pay tax on that in 10 years. They have a 10-year window under current law to pay all of the tax on that account because it's not all your money, it's yours and Uncle Sam's together. And you have the right to go ahead and pay some of that tax now at Roth conversions. You have to be strategic and intentional with those. Move the money from a tax-deferred account. You pay a little bit of tax now. Move it in a Roth account where it's tax-free. Those 2 strategies can really maximize the amount of money that your kids end up getting, regardless of documents. And so the tax advisor in me has to just mention those because so many people miss them, and that they can really maximize the amount of money they end up leaving. Action plan. tonight, write in plain English what it is that you'd want to have happen if you're not here anymore. You can't make decisions. And then within the next couple of weeks, draft or refresh the documents that you have, get documents drafted or updated. And then in a couple of weeks after that, usually it takes a little bit of time, update every account's beneficiary or asset titling. If you get a trust, you have to do a quitclaim deed, move the house into the trust. There's some updates there that you need to update. The beneficiary of your 401k is the trust and not your kids. And so there's some updates there that need to be done. I've seen that stuff. Like I said earlier, I don't think I've ever met a person who had all of that last step done. Where do you actually do this stuff? In my mind, there's really three options. One is a truly self-guided platform. Think LegalZoom, something like that. I'm not promoting them. It's just an option that's pretty well recognized by people. They've done a good job branding for years. Think like $300-$400, a simple estate. If you have do-it-yourself confidence and you're good to knock this stuff out, that can be a good option. Option two, a financial planner guided platform. Think a certified financial planner or tax advisor like me, that it's self-guided in a sense, but someone is guiding you and you want professional eyes and hand-holding through the process, but you don't want to pay a whole lot of money for a custom document. We charge like $1,200, depending on the scenario. Sometimes it's a little different, but usually somewhere around there, depending on the professional. Or attorney drafted original documents. Think higher net worth, complex family, special needs trust. I work with attorneys every week with our clients to draft original estate planning documents. Thinks $2,000 to $8,000 in most upper middle class households. That would be a good fit. If you're wealthy, definitely fees can be $100,000 if you're a billionaire. I don't know, but somewhere in that range. And again, whichever lane you choose, first figure out what it is that you want to have actually happen if you pass away. 2, draft the documents. And 3, don't skip 3. It's where most plans fail. Make sure that you update all your assets to align with those documents. Pause right now, open up the description, grab the estate plan checklist. It's the first link listed, and knock out the writing exercise, call it that, to figure out what you want to have happen. And then pick a platform, pick somebody to help you or do it yourself to get documents updated, and then you can exhale. It's one of the cooler parts of a financial planning process when people get estate planning documents done, that they like, okay, we're good. And the couple gets on the plane, little less anxiety, I guess you could say. If something happens to you, the things are taken care of. Also, subscribe to this channel to drop weekly videos to educate you on anything financial planning or tax advice. And just a reminder, this is intended to be educational only. It's not formal legal or tax advice. Talk to your own attorney or tax professional for that info. But hope this helps.